music? China? What are they even saying? What is this Chinese rap music? Sounds like they're just saying ching chang chong.
My chance new go watch made in China. We play ping pong ball made in China.
Hello and welcome to China Econ Talk. I'm your host, Jordan Schneider. Chinese law. What is it good for? Well, many things, but protecting Huawei from state security requests to help in overseas espionage? Probably not, according to this week's guest, Don Clark, professor of law at George Washington University. That's due to fundamental aspects of Chinese law that we'll discuss today. Don, welcome to China Econ Talk.
Thanks very much, Jordan. Happy to be here.
So first off, what got and kept you interested in Chinese law, and what sort of advantages or disadvantages do you feel between studying this sort of law and the types of stuff that your colleagues do, focusing on Western countries?
I was first in China from 77 to 79 as a student. And while browsing around in the Canadian Embassy Library one day, I came across one of the founding works in the field of PRC law. This is a book by Jerome Cohen called The Criminal Process in the People's Republic of China. It covered the period up to the Cultural Revolution. Of course, there wasn't much in writing, and as an American, he couldn't go to China, so he went to Hong Kong and interviewed lots of PRC immigrants, including not just ordinary citizens, but also legal officials. And they had fascinating stories to tell, and he wrote about it in a really interesting way, so that's what got me interested. What kept me interested was just the tremendous changes we've seen in China since the late 1970s. How could anyone be other than interested? As for the advantages of studying Chinese law compared with studying U.S. law, I guess one advantage is lots more opportunities to travel and meet interesting people, not just in China, but also in the community of Chinese law scholars outside of China. If you're a specialist in some aspect of U.S. law in the U.S., my guess is that you don't interact a lot with foreigners who study the same aspects of U.S. law. But if you're a specialist in Chinese law, you interact not just with Chinese legal scholars, but also scholars from all different countries who also study Chinese law. Second advantage, lots more open areas. There's still lots of basic stuff about the Chinese legal system that we don't know. And then I guess another advantage is more opportunities to be cross-disciplinary. When you study Chinese law, it's immediately obvious that you can't just look at doctrine. You also have to talk about politics, society, economics, throw in some anthropology, all sorts of other interesting fields that you can throw into the mix.
What do Chinese scholars think about foreigners studying their legal system? What is the kind of general tenor of the relationship between the foreign and domestic academic spheres?
In my experience, Chinese legal scholars, regardless of their views or political orientation, are actually remarkably welcoming of the efforts of non-Chinese studying their legal system. They read the work and they take it seriously. They have symposia to discuss works by non-Chinese scholars. You hear a lot of government officials saying that non-Chinese just don't understand China, but I don't hear that from Chinese scholars about non-Chinese scholars of China. And I think the respect definitely goes both ways. I remember back in the 80s when I started reading Chinese legal journals, it's fair to say that it wasn't very good. A lot of doctrinal exegeses, basically taking the text of some written law that was 50 words long and then explaining it in more detail in 500 words. But that was an era when the written law mattered even less than today, and nobody was looking at actual practice. Now, the picture today is totally different. There are still a few people doing the boring textual analysis, but there are many more who are widely read in the international literature, in a bunch of different disciplines, not just law, and who are doing really very interesting empirical investigations. There are just a lot of very bright and interesting people in the field now, and that, again, is what makes it a fun field to be in.
What are the downsides of studying a foreign country, and particularly the PRC's legal system?
Well, I guess one downside is you're more likely to be at least somewhat marginal in your home institution when you're studying a foreign legal system and not the U.S. legal system. Another downside, it's harder to do research, particularly in China. since the system is in principle closed, whereas the U.S. legal system is in principle open. This is a huge problem, not just for foreigners, although it's especially big for foreigners. Chinese face similar problems, although they can be overcome to a certain extent. For example, Chinese researchers, given enough time, can get judges to open up to them, can regularly observe court proceedings, and perhaps can even have access to court records of various kinds. Now, this is impossible for non-Chinese scholars. So, you have to choose your research subject with care to make sure it's something doable by someone who cannot get this kind of close insider look at how courts operate. Another difference is you can hope to have some kind of policy relevance if you're studying U.S. law, and legal scholarship in the U.S. can be explicitly about advocacy. For example, you can write an article setting forth your view about some aspect of the law of search and seizure and hope that maybe judges or at least litigators and professors will read it and that your ideas perhaps somehow will seep into the jurisprudence in the field. Well, that's not going to happen when you write about Chinese law. Scholars of Chinese law outside of China are not generally in the business of making arguments about what Chinese law ought to be, except perhaps as part of some incidental advocacy in, say, human rights. We're generally much more in the business of just trying to understand how the system operates.
Let's start in pre-PRC, pre-Republican era China. So what aspects of traditional Chinese law are important to note, and maybe talk a little bit about how Qing era stuff bleeds down into the present?
Well, there are a few important points about traditional Chinese law that I'd like to make about how it was different from the contemporary legal systems of Europe. So, unlike the legal systems of Europe, Chinese law does not trace its roots to the private law system of Rome or to any religious basis. Instead, traditional Chinese law during the imperial period centered on state concerns and dealt with private matters incidentally. So consider your typical medieval European monarch. These monarchs held themselves out as providers of justice, and they sought legitimacy on those grounds. They set up courts to encourage people to use their courts and not use the courts of the feudal lords. But in China, doing justice as such, I would say, was simply not part of a traditional Chinese ruler's job description. Keeping order was his job. So far from encouraging subjects to bring their disputes to state officials for resolution according to law, imperial officials from the emperor on down would encourage subjects to settle things amongst themselves and not disturb their betters. The second thing is that although imperial China, which of course had a very advanced bureaucracy, produced a great deal of documents of a kind of rule-like character, it had very few officials with the specialized function of interpreting and applying those rules. And their role was limited to the review of cases where a non-state actor was involved as a defendant. So basically we're talking criminal-type cases. There wasn't any institution that could apply law against the state. And below the level of the province, there were actually no legally specialized officials in legally specialized institutions. That is to say, nothing you could call a judge or a court. There was a local official in charge of a county whose title is traditionally translated as district magistrate, but I think that's very misleading, and so I prefer to call him the district superintendent. His responsibilities covered all aspects of government within his jurisdiction: tax collecting, bandit suppression, maintenance of post horses, things like that, and also, incidentally, cases of violations of the law. He had an office called the Yamen, that's sometimes translated as court, but again, that's misleading. Hearing disputes was just part of his overall job as an administrator. And, what's the relevance to the present, you asked? Well, a lot of these ideas can be seen even now. I won't go into detail, but in particular, I guess I would point to the relatively subordinate role of law. Again, it's viewed as part of overall government administration, and things we might think of as legal institutions, that is courts and judges, their job is really to function as administrators and as part of the overall task of administration. There is absolutely no acceptance of the idea of limited government or government under law, as we might say. The law is for the ruled, it's not for the rulers.
Sure. So let's fast forward then to 1912, and we have Republican China. So what new stuff gets thrown into the mix at this point in time?
Well, at this point, I guess what we get in Republican China is a few things. First of all, we now do get these special differentiated institutions that can handle matters that are specifically designated as legal. So we do get this kind of separation out from the ordinary business of government of this special set of tasks that are called legal and that require the attention of people who have specific legal training. Another very important element we get in Republican China, of course, is the ideology of popular sovereignty. That legitimacy comes from the people. This is, of course, not the case in traditional China. The emperor doesn't get legitimacy because he's elected. It doesn't get legitimacy because the people support him. He gets legitimacy from the mandate of heaven. Now, of course, this idea of popular sovereignty was somewhat diluted in that the ruling party, the Kuomintang, sometimes translated KMT, like the Communist Party after it, sees itself saw itself as the vanguard of the people. So the people didn't necessarily get a direct choice, but nevertheless, that ideology is important. And then finally, another kind of new thing we get is this notion of rights. Although it's important to remember that rights here were largely conceived of as good because of what they would do to strengthen the state. In other words, even in the late Qing, when Chinese thinkers were, casting around for solutions to China's problems. Why is China able to be bullied around by this tiny little island country, called England? And so they would say, well, what is it that makes the Europeans powerful? And one of the things they came up with was, it's this institution of rights and constitutional government. And so, Chinese thinkers in this particular, moment in Chinese history when China was, weak and under attack from European powers, of course, one of their main concerns was, how do we make China strong? It wasn't, what do we do that's good for the citizens? It's how do we make China strong? And so rights, this concept of rights was imported at this particular time. And so that's typically how rights were conceived of in that era and even today to a certain extent. So they're not valuable in themselves, but they're valuable for what they will do for society.
So a few things happen between 1912 and 1949, but let's get ourselves to the Mao era. So what happens with Mao Zedong on the helm?
Well, so if we think about the Mao era, I guess I'll call that, the era of classical socialism. We start off, of course, with quite a lot of instability and unrest. Even in 49, the Communist Party had, basically conquered the mainland, but they still had a lot of sweeping up to do, at least in their own view. So, that is followed by land reform, which was quite bloody. And economically, they wanted to follow the Soviet Union in having a planned economy. It's important to realize that the planned economy, in China was never remotely, as planned as the Soviet economy. When the Soviet economy was planning for, 10,000, 20,000 items, China was planning for, a few hundred, something like that. But the point is that in such an economy, a judicial system is either not really necessary or it does something quite different. So the judicial system as we know it is designed to resolve disputes among equals, based on rules known beforehand. And that's just not what the Mao era legal system was all about. So if you think about the economy as a kind of giant China incorporated, everything is done according to a plan. If you look at General Motors, for example, and the processes governing how resources move around inside General Motors, how are disagreements between employees or between employees and supervisors resolved? If the Chevrolet division wants more money to develop their cars and the Cadillac division wants more money to develop their cars, how do you resolve these policy differences? None of that looks like a legal system. It's an internal bureaucratic system. And the goal is not justice. The goal is maximization of profits through the production of cars. So I think that's a decent model for thinking about the legal system in the Mao era. It's not inherently good or bad. It's just you have to remember what it's trying to do. And what it's trying to do is not to deliver justice. What it's trying to do is to maximize some particular goal of the whole system.
Let's get to Deng Xiaoping and Gaigai Kaifang. And as the economy changed, you write that the need for a different type of rule of law increases.
Yeah, because it used to be, again, if you think about the legal system as similar to what you might get in a giant corporation or a giant bureaucracy like a university or even within a government, typically when you have disagreements, they're resolved by a common superior. So you have to find who's the boss of both the disagreeing parties, and then they both make their representations to that common superior, and the common superior decides. What do you do if people don't have a common superior? If you and I have a dispute, we don't have any kind of common bureaucratic superior that can resolve the dispute for us. And in a market economy, if you have a lot of private entrepreneurs, private enterprises, just individuals, not controlled by the state, not under the state, making their own individual decisions about things. So they don't have a common superior. So therefore, you have to have some different mechanism for governing their disputes, and that mechanism is, the legal system as we tend to think of it. So, given the nature of economic reform, the growing importance of the market, where people are supposed to be making individual decisions about what they want to buy and what they want to sell and at what price, the growing prominence of actors in that market who are not subject to a common superior, then you needed to have a fundamentally different system. And so the role of the courts, for example, changed quite a bit. In the Mao era, courts used to basically, what did they do? They put their seal of approval on criminal decisions that had been made elsewhere. They handled matters such as, divorce, things like that, but they did not handle cases involving massive amounts of resources, huge amounts of money. All of a sudden, in the post-Mao era, they were being called upon to handle these kinds of cases, civil cases that would involve perhaps massive amounts of money. And so you need, a different system to do that.
So looking back, it's pretty unbelievable just how much progress has been made in this regard.
Yeah. So there's been a lot of change. I'm a bit uncomfortable talking in
progress
terms of
may be the wrong word. Evolution.
Progress. Right. So let me explain here, because I don't, my feeling is not you can't talk about it, but I think one needs to separate out the time when you can talk about it and when you can't. So, I've used those terms myself. It's very difficult to avoid using those terms. But, talking about progress and regress does imply that there's some kind of a line along which all legal systems develop. And the kind of system we like is at one end, and then what we don't like is at the other end. And so what I see often in the Chinese law world, or the world of Chinese law scholarship, or people looking at Chinese law, is this kind of constant looking for hopeful signs, that something we like is developing. And I think that can really distort our understanding, because, we interpret everything through this lens of whether it might be the seed of something that could grow into something we like. So, village elections, wow, sprouts of democracy, or activist lawyers, well, this is the nascent independent bar. And it means that we don't contemplate the possibility that what we're looking at is really part of something else entirely, or maybe it's just a one-off that won't grow into anything. Now, there's nothing wrong with talking about progress and regress if you have and because you could explicitly have a set of values as a goal. And, there's nothing wrong with talking about progress toward those values. People should have values. But what I want to caution against is seeing that valued endpoint as somehow inherent in the internal logic of the way the system is developing. It's a goal you are hoping for, but it's not necessarily a goal that the system has.
Let's get into that then. So what are the fundamental points that the system is aiming around that people don't necessarily maybe appreciate from a casual Western lens?
So I guess I would say that the goal of the system now, even explicitly, and in the past perhaps implicitly, is, can be summed up in two words, which is stability maintenance, in Chinese Weiwen. We hear this phrase a lot, and it's not because we hear it as a buzzword that I'm saying it's the goal of the system, but it seems to me that when one looks at how the system, actually operates, that is what is driving it more than anything else. And by stability maintenance, I mean stability maintenance as viewed by the party, which means, that which maximizes the chances of the Chinese Communist Party staying in power. And then that has many subsidiary policy goals. For example, keeping petitioners, out of Beijing, for example. So, we see local officials having these, hard targets that no more than X number of petitioners from their district can show up in Beijing. And if they do, the local official is going to get in trouble. They have to, repress demonstrations and stuff like that in their own districts. Otherwise, they're going to get in trouble. We find courts, for example, one of the indexes on which judges are evaluated is the extent to which, their decisions result in some kind of mass protest or incident of what the party would call social instability. Nobody's asking whether the decision was right or wrong. That's not what the superior official wants to know. The superior official wants to know, why is someone having a hunger strike on the steps of the court, and attracting a big crowd? I don't want that happening. Make this stop happening. That's the imperative for local officials. It's to make, these incidents of instability go away. And it's not necessarily, the superior official is not that concerned with the rights and wrongs of the matter. That's just not on the assessment table.
So you write that a few of the central tensions in the Chinese legal system are local versus central, the idea of judicial independence, and which rules end up ruling. Could you talk about those a little bit?
Sure. So the first tension, local versus central, is about how much discretion local governments should have and do have. So, China, constitutionally speaking and, politically speaking, is a unitary state. It's not a federal state like Canada or the United States. Local governments have no protected sphere of power and authority. So, in other words, legally speaking, and to a certain extent politically speaking, whatever the central government wants, it gets, and the only limitation on that is simply one of, what is the actual power of the central government to do something? Because, of course, they're up in Beijing, and there's always a kind of asymmetry of information. Local officials know more about what's going on locally than central officials do. Because local officials are not, elected by the people below them, who are in a pretty good position to know what the local officials are doing and how well they're doing it, but instead selected by people above them, this problem is never going to go away. So the higher up officials always have this problem of not knowing exactly what the lower level officials are doing. So although they have the theoretical power, and when they really devote resources and attention to it, the actual power to, to make any particular thing happen at the local level, as a general matter, they have to delegate a lot to local governments. And so that is a constant source of tension in the system, that the central government wants to get certain things done, but it has to leave, a certain amount of authority as a practical matter to local governments. On the other hand, sometimes it works to the center's advantage because they can avoid the blame for certain policies.
If only Mao knew what was
Right.
going on in the provinces, right?
Exactly, and a lot of people, in China, really do think like this. There's all sorts of survey evidence to show that people have much more trust in the central government than they do in their local governments. There have been some interesting survey evidence about petitioners when they go to Beijing, and sort of they get surveyed the day they arrive and what their views of the central government are the day they arrive, and then they get surveyed by the same people like a week later, and what are their views of the central government. And it's really gone downhill in that week, but they arrive full of faith that the center will solve their problems, and it's just the evil local officials that have been hiding the truth from the center. So that's one tension there.
I've always found it interesting how that's just that's a legacy that you see in Songdai and Mingdai. I mean, it's an interesting tradition that's carried on until the 21st century.
Well, and not just in China. I mean, it was famous in Russia that the peasants and perhaps the workers would think that if only Stalin knew, what was being done. So I think it's probably inherent in any kind of centralized dictatorship. So
judicial
moving
independence.
on to judicial independence, right? So the issue there is how do you? This is not an issue unique to China, right? But the issue there is how do you get the kind of optimum mix of independence on the one hand and accountability on the other, because of course total independence means total non-accountability. And in the United States, for example, we go to one extreme. The system prizes independence even at the expense of accountability. If you look at the federal system, the almost the only way to really make a judge accountable is to impeach them. And that's a very, difficult process, almost never done. Judges, at particular levels maybe can be, criticized or disciplined. I don't know even how the system works, but
tweeted out.
There's not much that we do to make federal judges accountable. We just hope that, having gone through the confirmation process, that, we'll have the right people. But, not every country would choose that extreme. And, China doesn't choose that extreme. So just even as a theoretical matter, there's not an obvious answer to how to make, how to have this optimum mix of accountability and independence. And then part of the question is, well, independence from whom? And that is a big issue in China, because clearly there's no intention on anybody's part in China, at least not on the part of anybody who counts, to have judges independent from, whatever the Communist Party leadership might think. But there's a real issue as to the degree to which they should be independent from local governments. And the problem there is that judges at any given administrative level are appointed through a process which is essentially controlled by the party organization at that same administrative level. So a county judge would be appointed through a process controlled by the party organization at the county level. A judge in a provincial court would be appointed through a process controlled by the party organization at the provincial level, and also the funding for the court is controlled at the same administrative level. So what that means is that if a judge is receiving conflicting instructions, one from the powers that be at the same administrative level, and one from, for example, a superior court, they're going to follow the instructions from someone at the same administrative level, and that's troublesome, because what they should be doing, even within the Chinese system, is to be following their best interpretation of what the law, which was passed at the central level, says. Because, of course, as I mentioned, China being a unitary state where all power is at the center, local governments do not have the legal power or, really political or ideological authority to override what the center says. And so judges should be trying to do what the center tells them to do through its duly promulgated legislation, and not doing whatever local officials tell them to do. But in fact, the way the system is structured, they have really every incentive to do what local political power is telling them to do.
Yeah, you write that the PRC rejects the notion of a vertical separation of powers and also rejects the notion of a horizontal separation of powers between different branches of government. For example, the traditional troika of legislative, executive, and judicial branches. A necessary separation of functions is acknowledged, but constitutionally speaking, the NPC, the National People's Congress, informal legislature, sits at the apex of China's political power structure. But in reality, that position is occupied by the Standing Committee of the Politburo of the Chinese Communist Party. But both form and reality share the rejection of multiple power centers. And this ends up bleeding down all the way into questions of judicial independence at the at the local level.
Yes, I would agree totally with that.
I would hope so. You wrote it.
Okay.
Right. So lastly, which rules rule?
Okay, so this is, again, this actually goes back to the issue of local versus central. Which rules promulgated by whom? Is it promulgated by local governments, promulgated by which branch of local government, promulgated by the center? Is it the National People's Congress? Is it the State Council? This can be, extremely confusing. And there is a law in China called the Law on Legislation, which actually sets forth the kind of order of priority that different laws come in, and says that laws of kind of a lower level cannot contradict laws of a higher level. But then the question is, if you're a judge faced with contradictory laws, what do you actually do, especially given that it's the lower level law is more likely to be the one issued by the level of government that is in charge of you. And there was a very interesting case on this several years ago called the seed law case. And this involved a case where it had to be decided on the basis of one of two contradictory laws. And one of the laws was passed by the provincial People's Congress, and one was passed by the National People's Congress. And the judge in her decision said that she would apply the law of the National People's Congress because the law of the local People's Congress contradicted it, and she said therefore it was automatically, for that reason, invalid. And that created this huge stir. Even though she was simply applying the provision of the law and legislation, which said clearly, Chinese political system also endorses this concept that local governments cannot override the central government. What happened? This decision, incidentally, was not just her going out on a limb. There was a special body within the court called the Adjudication Committee, which consists of all the senior judges in the court president, who's going to be a politically connected, savvy person. They all approved of this decision, but nevertheless, it caused this huge fuss. The judge was disciplined. Interestingly, the case then was appealed up to the provincial level court, which came to the same result. It just did not use the inflammatory words to say that the local legislation was invalid. It didn't apply it. So in substance, it made it invalid, and it applied the central legislation. So they came to exactly the same result.
But just a little more mienza for everyone.
They were just hid the ball as to what they were doing rather than saying up front what they were doing. So this problem comes up a lot, this idea, this notion of conflicting rules. And it's still something of a problem in that, in practice, Chinese law seems to be a bit of an inverted pyramid in which the laws that are actually most important are the lower level ones and not the higher level ones. Whereas in theory, the laws that are most important are the higher ones and not the lower level ones.
So, how does Xi want the legal system to evolve? And what has he been doing in his time as top dog to push it in that direction?
That's an interesting question. I don't think Xi Jinping has any particularly profound thoughts about the legal system. My guess is that to him, there's nothing special about the legal system. It's just another set of administrative institutions through which to realize his policy goals. So, for example, are the police, are the Ministry of State Security, are they part of the legal system? It's not an important question. So they're just like the courts. They're all part of a state administration that operates in a similar fashion across the board. So I think as far as Xi is concerned, and I'm pretty sure other leaders would think the same way, the slogan strengthening the legal system means getting more people to obey orders more faithfully. There's absolutely no sign whatsoever that Xi or any other leader has any desire or intention to establish some set of non-party institutions that could act as a check upon the party as an institution or upon a party leader. What they want to tell you is the party will supervise itself. Thank you very much. No need for citizens to get involved.
So coming back to the topic I promised 40 minutes ago, Huawei and the legal system. So the central claim or the line that Huawei was putting out, I guess back a month ago, was basically saying that they have the wherewithal under Chinese law to say no to requests by the government to help with overseas espionage. Why don't you take it from there and maybe connect what you wrote to some of the things we've been talking about with regards to fundamental aspects of what's going on legally in China?
Okay, so there's two issues here. One is, what is the position under Chinese law? So if a Chinese government agent, walks into Huawei's offices and says you must cooperate. And let's not single out Huawei here, just any company operating in China, including a foreign-owned company. What is the position under Chinese law? So, that's an interesting question, but it's not the only question. And it's not even the most important question. The most important question is, what is the reality, regardless of what Chinese law says? So, in other words, does Chinese law matter in this case? So I guess let me talk about the position under Chinese law first. And then I'll talk about the reality, if that order makes sense.
Sure.
So many people have raised the issue of China's, national intelligence law, which basically says that, citizens and entities, have a duty to cooperate. And, what does this mean? And, Huawei last spring started circulating a legal opinion by a Chinese law firm called Zhongluan, which analyzed the position under Chinese law, the national intelligence law, and other statutes, and concluded that Huawei did not have an obligation. I read that opinion very closely and, frankly, was not impressed by its reasoning, particularly with respect to the national intelligence law. I think in some of the other laws, they were correct to say that those laws do not oblige Huawei or any other company to cooperate. But the arguments against the national intelligence law, I thought, were pretty weak. For example, the legal opinion circulated by Huawei stated that the national intelligence law protects the lawful rights and interests of Chinese companies, and that Huawei had a lawful right and interest in doing business overseas, and that if it were forced to install back doors or something in its equipment, that would compromise its lawful right and interest in doing business overseas, and therefore Huawei could say no. Now, I find that argument preposterous, frankly, that anything so vague as, and in Chinese law, one sees this all the time, lawful rights and interests, it really doesn't mean very much, that, such a vague provision could be elevated into this, great wall of resistance to Chinese government requests to cooperate. Another argument they said was that it would be unconstitutional because the Chinese constitution protects the rights of privacy of citizens, which strikes me as equally preposterous. for a number of reasons, including the fact that, of course, the concern is not the privacy of Chinese citizens. The concern is the privacy, etc., of foreign citizens, who, of course, are not protected under the Chinese constitution. So my feeling is, really, is this the best argument you can come up with to say that, the national intelligence law does not oblige Chinese citizens to cooperate? And if that's the best you can do, I have to say I'm not convinced. So the position under Chinese law, I think, is that they do need to cooperate. Then the question, what about reality? And I think the question of what the reality is even clearer. China, is in effect a Leninist state. They do not recognize legal limitations on the power of government to do what it wants to do. When the government agent comes into, the offices of a Chinese company, whether it's Huawei now or whether it's Yahoo China many years ago, in a famous case, and says, do this, you cannot say, well, the law says we don't have to, so we'd rather not, at which point the government agent says, okay, no problem, just asking, have a nice day. That's not how it works. When the government agent comes into your office and says you must do this, you have to do it. And it doesn't matter what Chinese law says, because the government is not meaningfully constrained by Chinese law.
You write that the need to distinguish between the formal system and what actually happens is very important. Such a gap, of course, is present in some degree in all countries, but in many areas it is particularly broad in China. And I would imagine that international espionage is certainly one of those areas.
Sort of national security related issues is one of those areas. So just take an example. The detentions in Xinjiang. So we have at least, it seems, 1 million, possibly well over that. So we're talking about at least 10% of the entire Uyghur population being detained in Xinjiang, utterly outside Chinese law. There is not any justification in Chinese law for these that anybody has offered. I have not found it. I have, asked Chinese legal experts. Nobody can come up with a explanation under Chinese law about how this can be done. It's always, well, it's necessary, but it's not, well, it's legal, So here we have, a giant set of exceptions to the government operating under law. That's just one example. We have, of course, many more, but I just offer that as an example.
You wrote this paper, which ended up causing quite a stir a month ago. Maybe talk a little bit about the reaction and how it seeped into the press and the response.
Okay, so the paper you're talking about, I assume, is the one on Huawei's alleged employee ownership. So this is a paper that I wrote together with Christopher Balding. Actually, it was Chris's inspiration to write the paper, and I came along a little later in the process. In which we argued, I guess I would say, in which we demonstrated that Huawei's employee ownership is not quite so straightforward as it seems, that what Huawei employees have at most is something called virtual shares. It's a kind of contractual right. We see it as a kind of a profit sharing scheme. And, the actual owner of Huawei Technologies is another company called Huawei Investment and Holding Company. That owns Huawei Technologies 100%. Huawei Investment and Holding Company has two shareholders. 1% shareholder is Ren Zhengfei, the founder of the company, and then 99% is owned by this kind of somewhat mysterious entity called the Huawei Investment and Holding Company Trade Union Committee. And
which among many things organizes Yumaqiu competitions.
Well, apparently that's what they say they do. So, but that's really the key to understanding Huawei, at least at a formal level, is understanding how this alleged trade union committee works and makes decisions. But I guess I was a little surprised at the reaction. I mean, the paper did cause quite a stir. It was downloaded like 1,000 times in the first 24 hours after being posted online. Huawei, called a press conference, denounced us by name. But the thing is that, contrary to almost all academics in their work, Chris and I at least speaking only for myself, maybe I shouldn't speak for Chris, but we take pride in the fact that this paper says absolutely nothing new or original. What do I mean by that? That if you Google, so our key argument is that what the Huawei employees own is not kind of real shares, but it's virtual shares, which are kind of contractual rights. And if you Google the Chinese terms for Huawei, together with the Chinese term for virtual shares, you get like 3.5 million hits. I did a comparable search in the English language literature, just preceding the publication or the publicity given our paper, looking in the Nexus database for any item which contained the words Huawei and also the term virtual shares. And I got one hit from about 2012, which was an article that mentioned in passing that some employees of an Indian subsidiary of Huawei had been given virtual shares. So that's it. So this whole idea of virtual shares in Huawei held by Huawei employees seems to have been completely unknown in the English-speaking world, even though it was utterly commonplace. Everybody knew about it. And they weren't even, it wasn't the secret, in the Chinese language world. I mean, I ran across a court case in which Huawei, sends a letter to the court explaining its, virtual shareholding system. And so I didn't realize that it was so little known, I guess, in the English-speaking world. And I was surprised that Huawei was so vehement about kind of denouncing what we said, when I guess their differences with us maybe are in interpretation, but certainly in the basic facts, we didn't say anything that hasn't been said a million times before. I mean, literally millions of times before in Chinese language media.
Do you want to proffer a guess as to why they were so sensitive to your critique, I guess?
I don't know. Maybe because it was made in English? Well, in a sense, we were saying that the system of employee ownership was, at the very least, not so clear as Huawei was making it out to be. Chris and I think, have somewhat different views on how far we want to go with an affirmative view of what's going on at Huawei as opposed to a view of what's not going on at Huawei. We also, pointed out that if it's really owned by a union, and if 99% of the shares of Huawei Investment and Holding Company are really owned by a union, then that means that there's a very significant element of state control, because unions in China are not independent; they're kind of quasi-state bodies, and indeed, if any particular union goes gets liquidated, that is dissolved, where do its assets go? They do not go to the members of the union. They go upwards to the
interesting
union body at the next highest administrative level. So that raises this interesting question of, well, what happens to these? Obviously, the trade union committee is not going to get dissolved or liquidated anytime soon, but it's just kind of an interesting thought experiment to see who has kind of ultimate ownership or interest in these shares, and that's still somewhat mysterious.
So in closing, Don, any advice for students out there interested in learning more about Chinese law, what they should read, tips for getting into legal Chinese? And then maybe going from learning to legal Chinese to actually understanding how the real law works?
Sure. Well, Chinese is hard, but legal Chinese is not that hard. It's not especially harder than Chinese. So, I teach U.S. corporations law as well as Chinese law, and I feel truly sorry for the non-native speakers, actually the native speakers as well, who have to wade their way through the thickets of the Delaware statute on corporations. It's a nightmare. You have sentences that go on for like half a page, all in legalese. Legal Chinese is not like that. It's not a nightmare because by and large, it's not written by lawyers, and it's not intended to be closely parsed by legally trained judges. So the way to learn legal Chinese is basically just to read a lot of documents of the type you want to learn to read, academic articles, legislation, contracts, to learn legal Chinese in the sense of learning how to express non-Chinese legal concepts in Chinese. How do you translate a piece of U.S. legislation into Chinese? How do you translate a contract that's written, for Americans and American courts? How do you translate that into Chinese? Probably the best way is to look at the filings of Chinese companies listing on the on the Hong Kong Stock Exchange, because often their disclosure documents will be in both languages, and those documents might include key contracts, corporate charters, things like that. Those translations are very carefully done. They put a lot of money into getting those right, so the translations are usually quite good, and thus comparing the English and the Chinese can be very helpful for learning. But learning legal Chinese, if there is such a thing, doesn't tell you anything about how the system works, except to the extent that what I said before, which is that learning legal Chinese to express Chinese legal concepts isn't that hard. That already tells you something about the system.
Interesting.
So for understanding how the system works, I guess the best thing to do is, if you're a student at an institution where a Chinese law course is offered, take the course. But if you can't do that, I have a few recommendations. First of all, you have to understand how the political system works and the role of the Communist Party, because you just cannot separate the Chinese legal system from the political system. So, for example, as I mentioned, this legal opinion about Huawei's obligations under Chinese law, is substantially incomplete, because even if everything it said about Chinese law was accurate, that would not answer the question that really matters, which is, what are the actual obligations, and to what extent, does the legal system count? It's a subdivision of the political system. So, read up on that. There are now quite a number of good books and articles being written on various aspects of the Chinese legal system. I would actually still recommend Jerome Cohen's book that I mentioned at the beginning of the podcast on the criminal process in the PRC, the one that I read so many years ago, even though it's quite old now. I looked at it again recently, and it's quite interesting to see how many continuities there actually are. If you're interested in, criminal law and criminal procedure, which is, a big part of the system, there's a more recent book in 2011. It's quite well done, based on a lot of field work and interviews, called Criminal Justice in China, an Empirical Inquiry. And on that subject, that's, I think, quite a well-done book. There's one recent book that I would single out as one that I think everyone with any interest in the Chinese legal system, and even just maybe the Chinese political system, must read, by Kwai-Hang Eng, K-W-A-I-H-A-N-G, last name N-G, and his co-author Xin He, X-I-N, surname H-E, which is called Embedded Courts, Judicial Decision-Making in China. I just love this book. It's based on a lot of field work and interviews by the two authors over the last several years. And it's both theoretically sophisticated and full of, great anecdotes and quotes from their interviews. It gives you this great feel, I think, for how courts operate. Of course, courts are not the whole legal system. There's a lot more to it than that. But the courts are still pretty important. And so understanding how they operate is important. Finally, I would give a shout out to the China Law blog, which is about, I just Googled the words China Law blog, which is about legal aspects of doing business in China from the standpoint of lawyers in a kind of a small boutique firm that deals with a lot of smaller clients, and not one of the giant New York firms that deals only with big multinationals. I like their perspective because I think it gives you a much truer feel for what everyday law is like in China.
Go back to episode 47 for Dan Harris's Rubber Duckies and Semiconductors.
Right. Well, great. Because, the big multinationals, they don't get treated the same way as everyone else. I remember being astonished, several years ago, the CEO of Coca-Cola Company, I forget his name, said that China had a better environment for business than the United States. Okay, so maybe if you're a giant multinational, you go to China, you meet the top leaders, you can negotiate your own special deal. But, for a typical small company, I mean, you have to, if you want to move your main office from one district in Beijing to another district, you have to get special permission, jump through all kinds of hoops. That's just one example. But the point is, I think the small company, kind of small investor perspective gives you a much more realistic view of what's going on in China. And so I find that blog very interesting.
Don Clark, thanks for being a part of China Econ Talk.
My pleasure. Glad to chat with you.
China Econ Talk is edited by Jason McRonald and Kaiser Kuo and is a proud member of the Sinica Network from SUP China. For other great shows on China, check out the Caixin Sinica Business Brief, the Pan Daily Tech Buzz China, the New Voices Podcast, and of course, the Sinica Podcast, now in its 9th year. Until next week.
Kind